Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
How the New York Times actively vouched for the veracity of its false narrative.
We actually want all evidence to come out that, that's proper and appropriate evidence.
How the New York Times actively supported the credibility of its false narrative.
So we kind of knew this was coming, didn't we? The collusion argument.
Blake Lively's lawyer quit after Brian Friedman dropped a major update in their lawsuit, and honestly, it's not surprising to me. Moral content was clearly drowning from the very beginning, trying to defend a case built on nothing but smoke and mirrors. Let's face it, only a professional magician could have pulled that off.
I looked through every document, every email, every text message.
Quitting was probably the best move to save her reputation from going down with that sinking ship.
You guys were complicit here. You guys were involved in this every step of the way.
And after this news, Blake Lively's legal team is officially in chaos. And honestly, it's about time. No one, not even her, can blame her.
That's the whole point of a lawsuit, is you just start with allegations, and allegations are not evidence. They're just statements of fact that help establish this is the claim that I'm bringing.
A case that's slowly falling apart with no solid evidence to back up Blake's claims is like trying to put out a fire with gasoline. As soon as Brian Friedman dropped his bombshell update, it was clear this case was in freefall.
Look, there's a lot of factual determinations that need to be made here, not legal determinations. And because there's factual determinations, you got to leave it to the jury. You got to give a jury the property.
Yeah, exactly. And so they're just saying, look, just let the facts decide. And the trier of fact in any case is going to be the jury. Unless it's a bench trial, then it's a judge. But this is not. This is a jury trial.
At first, Blake's case looked like it had potential. Sexual harassment, body shaming, breastfeeding allegations, all the perfect ingredients for a public sympathy play. But the reality is, there's not a shred of proof to back any of it.
There's some bad things that happen here.
The more Justin Baldoni's team dug in, the more Blake's accusations started to look like a poorly written script. No messages, no documents, nothing to show she wasn't just making stuff up. Every time Blake's legal team thought they had a leg to stand on, it turned into quicksand.
They hired the Wayfair parties, hired the crisis PR manager who orchestrated a smear campaign against Lively.
Now here's the kicker. Blake's PR team had a hand in all this too. While it might have looked like they were all about fighting for justice, in reality, it was about maintaining an image. They kept pushing Conan and the team to fight, even though there was zero proof to back up Blake's claims.
It wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
I mean, maybe they thought some good old PR spin could magically make the case win, but in reality, the court doesn't care how many Instagram posts you make. It's all about the facts.
Reynolds and Lively wanted Wayfair to issue a statement taking the blame for Lively's bad press.
As if that wasn't enough, Conant was under immense pressure from every angle. She's representing Blake, a high-profile client who wants to win at all costs, even when the evidence just isn't there.
Baldoni's team drops a massive $400 million suit on Blake and a lawsuit against the New York Times. Then they publish 170 pages of perfectly documented texts and emails between all the parties that basically show Blake to be the aggressor. Here's the proof.
Then, of course, came the 170-page legal release from Baldon's team.
Yeah, and again, at the same time, Nathan assembled a team that could dominate social media through full social account takedowns by starting threads or series and,
Hold that thought.
here we go, generally working to change the narrative. So it's impossible to know how much they planted and how much of it originated organically. Well, wait a minute.
This document wasn't just a challenge to Blake's case. It pretty much shredded it to pieces. The claims of sexual harassment, non-existent. Body shaming, not even close.
You're making a factual assertion that these people did something, seizing on it and amplifying it.
In fact, everything Blake said was systematically debunked. The more the case unfolded, the more it looked like Blake was the one trying to play the victim. No evidence, just a whole lot of claims. And the more Conant fought, the more she realized she was defending nothing.
This suit against the New York Times is hard.
Now, you might be wondering if this was the problem. Why didn't she see it coming from day one? Well, I don't know if you remember, But there was a time when the media giant, the New York Times, slapped its stamp of approval on Blake's case. And back then, it felt like a win.
Here is
And a legal
the clip in question. Now, this
complaint
video,
likely filed on Friday.
thank you to
Private
Citizen
text
Journalist
messages.
for putting it on easily accessible. This was part of the article.
Poor Blake Lively's legal team probably thought they hit the jackpot when the New York Times published an article and video in December 2024, making her claims look practically bulletproof.
A campaign to tarnish Lively after she alleged that Justin Baldoni, her co-star and director, and Jamie Heath, the producer, had engaged in misconduct while shooting the film.
Oh, the sweet taste of mainstream media credibility. For a brief, shining moment, it seemed like Blake had found the holy grail of support. The piece, titled "We Can Bury Anyone Inside a Hollywood Smear Machine," was like her golden ticket, a last-ditch PR move to make her accusations against Justin Baldoni and Wayfair Studios look as legitimate as a courtroom verdict.
And that's what the New York Times is coming back and saying, look, we're not Blake Lively. We're not the ones making the allegation. We're just fairly reporting on what Blake is suing Justin and Wayfair for.
After all, if the Times, the very same media giant that's been making history for decades, puts its stamp of approval on something, it must be true, right?
They decided not to run it for fear of defamation, I'm sure, for fear of you and defamation. So they didn't run it. But some of these TikTokers have done it.
But as with most things that seem too good to be true, the reality hit Blake's team harder than they expected. Just when they thought they had the Times in their corner, Justin Baldoni's legal bulldog, Brian Friedman, stepped up with a counterpunch that would have knocked the wind out of anyone. Friedman wasted no time filing an opposition to dismiss the New York Times' involvement in the case. And to be honest, it was a masterclass in legal smackdowns.
He mocked Baldoni in the process. He said, it's an effed up bad situation with what Baldoni, whatever his name is doing.
According to Friedman, the New York Times wasn't just reporting on Blake's allegations. They were practically validating them as fact, presenting them in such a way that it was hard to tell if they were writing a news article or an editorial. Friedman made it clear that the Times didn't just play reporter, they played advocate.
If they would have said, Blake alleges that, or according to Blake, blah, 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 this happened, they'd be protected. But they said, and her title is investigative journalist. So she's investigative journalist for the New York Times. So that is implying that she's done an investigation. She's actually looked in this. We can trust her.
Friedman didn't stop at accusing the Times of bias. Oh no, he dug in deeper, accusing them of violating the fair report privilege, which protects media outlets when reporting on legal matters. You know, the kind of protection that allows journalists to report on court cases without getting dragged into the drama themselves.
The New York Times have looked into it, and this is what really happened. So now they're stating as a fact, not as an opinion, that this happened, and that's how they're going to get into trouble.
But here's the kicker. According to Friedman, the Times didn't just report on Lively's claims, they framed them as truth. They didn't just tell the public, hey, Blake says this happened. They implied it had already been investigated and confirmed. That's not reporting, that's shaping a narrative.
Admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation.
And by doing so, the Times lost the shield that comes with fair report privilege. In other words, they exposed themselves to a lawsuit. Genius move, huh? Friedman's legal challenge was a bombshell in itself. He argued that the Times was not just guilty of sloppy journalism, but of actively participating in the destruction of the Wayfair party's reputations.
If they're supposed to be the bastion of journalism, right? But, if they had just said it's the opinion, would this have mattered? Will this factor in the fact that they did seemingly have this for months due to the metadata and things that we're seeing?
It admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times own investigation.
And so now they're saying like, hey, we tried to fact check. We gave you the opportunity. Oh, you didn't respond. Oh, if you would have responded, we would have maybe thought of things differently. But hey, we just went with what we had, so we can't be sued. So this is what they're doing.
They presented Lively's version of events as though they were not only verified but unquestionably true. And that's a big problem, legally speaking, because media outlets aren't allowed to present unverified claims as facts.
So here's why he's suing them. It's super creative. They said, evening of December 20th, hey, Justin, here's all this horrible stuff we're going to print about you. You have until tomorrow at noon. We'd love to hear your response. He engages with them. He says, okay.
It's one thing to say, this is what someone is claiming, but it's another to say, this is what happened, especially when you haven't done the legwork to prove it. The line between journalism and advocacy got a little too blurry, and Friedman was ready to call it out.
And New York Times prints a story prior to noon with partial information. And my guess is they were worried another outlet was going to hit this story.
Oh, but wait, it gets better. The publication of the article and video wasn't just shady because of the way the story was framed, it was also rushed out with questionable timing. Friedman pointed out that the Times essentially shoved this piece out during the holidays, giving the Wayfair parties almost no time to respond.
We're talking about the Wayfair parties over here, and it to me makes it sound like the Wayfair parties did that. And again, if that's the case, if you think that that happened, investigate it. Do a series of articles. Let's see it.
It was like they knew exactly when to drop the bombshell for maximum impact, and that timing just so happened to fit perfectly with Blake's PR strategy.
It's not unlikely. I think there's a high degree of likelihood that the court probably, on one of the arguments, and maybe it's the group pleadings, but will grant the 12b6 motion and ask Baldoni's side to amend the complaint.
According to Friedman, this wasn't just poor journalism, it was bad faith. The Times, it seemed, was already committed to the story before they even gave the other side a fair shot to defend themselves.
So you might as well just amend the complaint and clean it up now. So it wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
The fact that the story had already been finalized days before the Wayfair parties were even contacted, yeah, that didn't look good. It made it seem like the Times wasn't interested in the truth. They were just interested in the narrative.
I mean, the arguments were really strong, so that wouldn't surprise me either.
All right. Oof, that was a marathon.
Friedman didn't just take issue with the timing. He threw shade at the entire ethical approach behind the Times piece. It wasn't just a matter of bad timing or poor editing. It was about the fact that the media outlet had already chosen sides.
An intimacy coordinator, and Blake refused to meet with him or denied, said, I don't need to meet with the intimacy coordinator. I'll see you on set. I'm all good. So, then Baldoni is tasked as the director with going to break down what happened when he met with the intimacy coordinator so he could get her up to date on it all.
They hadn't just reported Blake's claims, they'd already decided to back her up, leaving little room for anyone else's version of the story. It wasn't a fair and balanced report. It was a one-sided endorsement masquerading as journalism. For Friedman, that crossed a line.
And they're arguing that California's tort claims, etc., damages in California are different because make their personal and professional homes. They may make claims in California.
But what Justin is saying is that California's substantive law should apply on this placing somebody in a false light